Welcome back to the Supreme Court headquarters. Now, here is where the Court of Appeal is having an open court. It's very interesting observations. Actually, from where I sit, it's a mixed bag. From where we are, you wouldn't know which direction this ruling is taking this afternoon. It started very chill in the morning. It started with about 3 judges. Now we have 4 to go. Very interesting because when it began with the president of the Court of Appeal just making that case, and then it went to the other judges, you would have thought that it's leaning a particular way. Then we had Justice Ichale coming in and challenging everything. Then now it looks as though it's not what we expected. But again, it's not yet over until the final pronouncement is made by the head of the court, the president of the court, that's Justice Musinga. So let's get to this discussion. I have Judge Kithi here, but we're waiting for other lawyers. As soon as they join in, we'll be speaking to them. Judge, thank you for coming. It's very interesting. We have been watching this and trying to read even the body language of the judges. At one point, you think it's going to favor the proponents, then suddenly it favors the opponents, then it's a mixed bag completely. You can't predict as at this point how this is going to end.
Yes. It's interesting. It is interesting because these are like penalties in a game where there are 5 bullets and they have either to be in or out. Okay. Unfortunately, there can't be an extension on this. What I'll say is this, just so that we pick this up. A judgment is a mere expression of a judge on his opinion on the law as applied in a circumstances that is controversial or the controversy before him. So much so that then that expression can be varied. Now, the process of judgment writing, I speak on account of the practice in this country and most jurisprudence that probably follow the common law processes, is that the judges will probably agree, if the issues are not as contentious as they look now, they will sit down and agree that the judgment writing is cascaded. For instance, the most junior judge can do the first draft, and then it goes for discussion in the panel, so that then they adopt one decision, and therefore it becomes a unanimous decision.
Yes.
Now, this is contentious, as we have seen. And the opinions come in different ways. Even the manner in which the judges express themselves, it comes also in much variegated ways, so that then there's many opinions as there are judges. Now, the most important thing is then what is the conclusion of the judge as he walks through the path of reasoning and analysis, so that then he obtains the constructive nature of applying the law with the facts that are before the judge. Remember, this is not the first hearing. The first hearing was in the High Court. A decision was made. So the judges are mere analyzing what the High Court said and applying it in contextual terms, and probably also infusing the law in the manner in which they understand it. So there are very many issues that need to be discussed. For instance, there are 22 resolutions that were made. What I have seen in what is constant that runs through the thread is an understanding that the president was not served. And therefore, the president was not served, and therefore, the High Court could not have made decisions against somebody who was not heard. Remember, the issue of service is a personal service.
It has to be personal.
Yes.
You can't do it through email.
You can't.
Or SMS.
Now you can, but the manner in which it was done was not investigated by the High Court. And the Attorney General did not represent the president in the High Court. And therefore it was wrong for the High Court to pronounce itself, whether right or wrong, but to pronounce itself in the manner in which it did. The only outstanding issue continuously is that it is the Court of Appeal seems to agree that the president can be sued in his name if he abrogates provision of the Constitution, but not in this instance because Uhuru Muigai Kenyatta was not served. And that seems then to put him out of all the resolutions against the president that were made, which were only 3. Now the rest. What is confounding here is that there seems to be a constant thread. They agree that this process was initiated by Raila Odinga and Uhuru Muigai Kenyatta after the handshake. That seems to be an agreement. Now, what I have seen also, there's a hardline stand that have been taken by Justice Sichale, and she seems to overturn all decisions invariably and disagreed with the High Court. Some the president has agreed with, some he hasn't agreed. The third in the process, because it goes with seniority ordinarily, has also disagreed with the High Court in some issues, but most of the issues he has agreed. So what we are saying is, so far we have two agreeing with the High Court.
So far,
and it is not clear because the majority haven't spoken
themselves. Because we still have four.
Yes.
The question is, looking at the judgment, how it was written and how it's being read, it sounds like individual judges making their own individual observations right now. This is not unanimous.
Yes, like I said, the first one, of course, is to sit and agree on a conference how to proceed and write the judgment. This one, they seem not to have gone for conferencing at all. They seem to have said, let everyone stand for himself, do your own judgment, and get your time to read it. And then they get the
summary. And it's really interesting how they summarize. I'd like to take you to Sichali there.
Yes.
Because her observations were just out of this world. For example, on IEBC, and if it was properly constituted, that caught my attention.
Yes. Well, she agrees that the constitution of IEBC is twofold. The first school of thought is whether composition is in the constitution or in the statutory legislation, which is the act that constitutes IEBC. But there's a difference between composition and quorum. Composition is if there's an institution like a board that is formed, meaning the commission itself, how many commissioners will there be? Now, that is not quorum. Quorum is at the time you're making a resolution, any other resolution, are you properly constituted? So you don't have to be the full composition, you have to be a minimum threshold of that composition, which was the investigation that was being made. Yes.
That's interesting because Tuyot J also mentioned, and at some point when they mentioned 3, 5, and 7. Maximum is 9.
Yes.
7 can work, but he took it to 5 and said it can be 5 or 4, but it can never be 3.
Yes.
Yeah.
Now, what the threshold is on percentages.
Okay.
Now, when you have the most minimum percentage that revolves to 3, because I've seen one has said 3, one has said 4.
Okay.
So they seem to be in a disagreement on what
just because of one.
Yes.
But it's a technicality, Wakili. If the whole process will be dismissed because of composition of the IBC at that time.
Yes, because it's a resolution that ought to be binding. If it is not binding, then it is not binding because the person who made the decision, remember a person is a legal person.
Yes.
The person we are talking here making the decision is IBC. The person must be properly constituted. For instance, you must be sent to make a decision. You must be capacitated enough to make a decision. So if a board, in making a resolution, is not properly constituted, meaning that those that are endowed to make the decision, the persons were not properly constituted in terms of numbers, even that in itself becomes in law a departure from what would have been the correct threshold. And to that extent, therefore, if the threshold is low, as ought to have been in law, then it means, therefore, that the decision that was made is not binding. Now, constantly what you find in these decisions is there's the issue of quorum, the issue of the procedural process in which this ought to have been conducted.
Yes.
Now, procedure, like we say, is the handmaiden of substance. It means, therefore, the substance become unattainable, and in fact, it cannot continue to stand if the procedure towards that substance or attaining that substance had not been followed. So remember that constantly you should look at the process. Remember, it's always about the process.
Because it determines the outcome.
Yes.
If it was flawed at the beginning, you can't say there's a justification.
Yes, the closest they've reached to looking at substance is whether then we can have a cocktail of questions as much as that complement the sections that have been proposed for amendment in the Constitution in the BBI, or we should have one question. And I think there's been also varied opinion of the judges, the last being that that it is not possible to subject a cocktail that is not interlinked, a cocktail of issues that are not interlinked into one question. So we're still hearing that. Let's see. But I want to say it's a big day for purposes of jurisprudence. We're developing as a country.
Whatever happens,
whatever happens, it is a plus for this country
to
fine-tune the application and service of the Constitution to
and of course, to stretch the Constitution. There's so many areas that go untested. And the most remarkable thing about this is we're trying to change this Constitution, right? And yet it's not been fully tested or fully stretched.
It happens. It happens a lot because those that we've tested, for instance, like the executive, well, we've applied it over time, and we are seeing, for instance, that probably the issues that we need to introduce to suit our political dispensation, our ethnicity, and our composition as a country. So yes, there's so much that we haven't tested in the Constitution. Its elasticity hasn't been tested to the maximum, but it is good that these things happen, because what happens is even Kenyans in this world where technology and communication is easy, as is happening now, they get to be educated on what then the Constitution is all about and how it serves them.
Now that we talk about processes, I'd like to take you back to Sichale J, and then bring you to Gatembo J.
Yes.
In terms of verification of signatures, if you look at Sichale, what she said about verification, the fact that IBC published them on their website and there was time to verify, to her, that was adequate for verification of signatures. But on the flip side, Gatembo thinks no. One, he is questioning what was the rush. And he says IBC violated their own principles by publishing it over the weekend.
Now, there's the problem, I think, is varied in this, that there's a minimum period, there's a maximum period of time, Sichale seems to be looking at. The maximum period of time is 7 days within which this ought to have been done, in terms of giving the public the time to look into their names and verify their signatures and so on and so forth, and that the publication was done because a notice had been given previously on where the publication was going to be done anyway.
On the website, yes.
Now, what Gatembo seems to be saying is, if you have put a threshold, meaning 7 days within which that verification ought to have been done, you create a legitimate expectation on the people that I don't have to do it in the 3rd day, on the 4th day, I can do it on the 7th day. Now, when you create your own rules and promulgate them or express them to the public, for the public to know and consider, and you've given the leges of 7 days within which that will be done, but then you reduce them to only a weekend, it means, therefore, you've disenfranchised people. For instance, the people who are not available in those 2 days, but will have been available within the 7 days. That is now the school of thought that Gatembo is coming from. Sichale's position is, was I required to publish? Yes, I was. Did I publish? Yes, I did. And I complied. So you can comply even at the minimum. And Gatembo seems to say, if you are going to comply, you must comply to the maximum, because then you have to give the maximum to the people. To the people, because they need to scrutinize. The reason why that's important, Wakili, is it was one of the major issues of contention. Because it was said the IBC lacks a framework to verify signatures. Now, that's a very important question. The contention was IBC has no law to follow. Either it is written or it is unwritten. If it is not written, it doesn't become something for me to comply with. So, if I have not been told, in verification, I follow the following things. For instance, I employ the services of DCI to verify the signatures. That is not written. So the compliance element here was, what did I do constructively and evidentially for me to have complied? For instance, if there's a name without a signature, I'll delete that. So that I have a minimum number, the most of that minimum being everybody has a signature and ID number. That becomes a verifiable list. I take that and I publish it in the website. Then people have to check that. Now, the other argument by Gatembo J was that, notwithstanding that the Constitution has provision which have not been enabled through legislation, if your role as a commission is to comply with those provisions, you must comply anyway. How? It must be to the threshold as envisaged in the past, the spirit of the Constitution. Now, that is where the opinion differ between the two judges. Now, like I said, the beauty about law and lawyers is that there can be as many opinions as lawyers are in this country. Now, the opinion of Sichale is that if they went through the process as explained, and to them, because they are not commanded by any statute or any law on what to do, and they did what they did, it was then reasonable within the scope of the existence of that environment that they complied. Yet Gatembo says he elevates the status and says you must then comply to the extent that is required of the standard set out by the Constitution. The threshold being the constitutional threshold, and yet as Sichale looks at the threshold being complies within the administrative and environment as would be outstanding and obtaining as at the time that the task is supposed to be executed.
Okay, away from that, the other issue that was hot, and actually it was spoken about across the board, is the basic structure principle. All the arguments, for me, they all seem to agree on one thing that is applicable within the Kenyan context.
Yes.
Yes, that was a unanimous agreement.
Yes, there is.
But the argument by the lawyers for the proponents of ODM, they were saying it's not. You're importing a foreign object to the Kenyan constitution.
Now, it has been an evolving concept in legal practice. You see, basic structure is this. What is a constitution? It is a contract between those that are ruled and those that are rule the people. That is, people saying, this is how you're going to rule us. What are the contents? There'll be an executive as an arm of government, there'll be judiciary, and there'll be parliament. What are their roles? Now, what you can change is the fact that you can say executive, for instance, will be expanded and put prime minister and deputy prime minister. That changes it. But the executive still remains. Mm-hmm. Judiciary, you can say there'll be a Supreme Court. Okay, like we used to have the Court of Appeal, then we put a Supreme Court. You can then remove the Supreme Court and only put the Court of Appeal. But judiciary remains.
Yeah.
In Parliament, we have, for instance, two houses. We have Senate and we have the National Assembly. But again, we can say, why do we need the Senate, for instance? We can only put the National Assembly, and that debate has been there on and off. And you know, also the assemblies which are there, the county assemblies. Now, that is the scope of representation, but what we are saying is the structure is there, which is we have executive, we have legislation, we have the legislature, and we have... Now, they agree that that is the most minimum. I would call it the irreducible minimum in the structure.
Okay.
You can't alter that. The question as to whether you can change the constitution through dismemberment,
yes,
or through overhaul, or through amendment, is what they've traveled the journey of looking at the history of our country. Mm-hmm. What they agree, and they seem to disagree with the past, is in 1963 that constitution was amended and dismembered so many times, such as to lose its identity completely. The abuse because of the powers as were then. I think Sichale took us through that process very well. Fast forward to where we are today. Where we are is that we have created a constitution recognizing the power of the people in donating a trust to the people who sit in those positions as trustees to the people of Kenya. You can't therefore take that away, and the basic structure of the constitution must continue to remain. In fact, they went ahead continuously and as a thread throughout the decision to say this, that there is no generation that cannot and must live for future generation. Generations must make decisions for themselves. So what they are saying is this generation can only remove, in fact, it can change the entire constitution through the process that removed the previous constitution. But you cannot dismember the constitution such as to lose its identity, the structure that makes the constitution what it is.
Okay.
Yes.
And when they were talking about, especially Sichale J, she agreed that if you are going to allow citizens to amend the constitution, you can allow them to either increase, even I'm talking about now Article 89.1, increase the number of constituencies, reduce the number of constituencies. You cannot limit their right. Now, my question is, what will this be down to? The right of citizens to amend the constitution versus the arguments around the initiator and the promoters. Where will it end? Because that is big when you look at the process. One of the problems that the opponents had is that the president cannot initiate this process, cannot promote this process. But if you look at that, where will it end? The right of the citizens, or just because of a process, this cannot happen?
There's a lot of emphasis in law and process, unfortunately. And the reason for that is because, and let me put it in context, those that propose that the president didn't have powers seem to be saying this, that if you are ruling me, don't tell me how you will rule me. I give you the power of a president, I tell you how you will rule me.
Okay.
And therefore, it's not available for the president to tell people, I am the president as it is, I will rule you in this manner. It is then, the suspicion is you will oppress us or put you see, you are dominating on us. You've conquered us and you've dominated through the suffrage system, universal suffrage, so that then you're the president. Now, when you change rules as we gave you when you're already president, it means you are trying to expand dominance and powers. And that may not be the case. But you see, the suspicion is there. The reason why we put checks and balances is mere because there will be suspicion, or we entertain suspicion as to what you can do in terms of your dominance and abusing power. That's why there seems to be the proposition that if president is in power and he proposes himself to amend how the social contract, then he would want to impose himself on the people. The other one, and that's not a constant, that's not always the case anyway, because some presidents do this in good faith. The other one will be that we, as people of Kenya, can change the social contract with the president, even if he's sitting in power, and tell him that your powers will be this and this and this, and therefore that the composition of the executive, you as the president will reduce your powers and donate those powers to someone else like the prime minister and so on and so forth. That becomes another social contract. And therefore you realize that there seems, the check we have here, which seems to be the emphasis throughout, or that if a sitting president sits, let him not initiate the amendments because he has a vantage point. He can even say the term of the president be 3 years, 3 terms instead of 2 terms. Which is possible. He can propose that if he wants. We can agree or refuse. But you see, it is also dangerous because then he continues to dominate over the people away from the social, the contract that he had with the people who's coming into power. And therefore, I think the debate as to who is the initiator and who is the promoter will continue. It may not even be settled in this case. We may have to look for a way of settling it out. And I suspect that this matter is not ending today. It may have to be tested again in the Supreme Court.
The most interesting thing is what Sichale J said, that you cannot limit the president's right just because he is president.
That is one school of thought. Remember, if you become president, you still don't lose the fundamental rights and protection in the Constitution. The right to life, right to own property, and so on and so forth. The other one, which is equally an aggressive argument, would be this, that as a president, you have been elevated to a position in society. Therefore, you lose your past. You lose the position you held previously. So if you assume a certain personality, it means there's a previous personality that you used to have. So that then it is not the same as Mama Mboga, a tout in Kayole, a farmer in Kericho, and so on and so forth. You are not the same person because then we protect you. We give you certain insulation. You do not behave and carry yourself as a normal person because you represent a status and symbol of the country. When we do that, then you lose certain rights. And that seems to be one of the sayings, that you lose the right to propose. Yet, it is painful to say that if you give me a position, I lose certain rights such as those. Probably that means much to me than it is to be president. Now, you choose to be president and agree to hold that position, it comes with ramification. The definitive element is, do you lose or don't you use the right to be an initiator and a promoter of the constitution changes?
Very interesting. But at the end of the day, I'm still thinking, when it's finally decided, will it be on the basis of majority? And the reason why I'm asking, because again, that decision, whatever way it goes, it affects a larger group of people.
This is what I think will happen now. There ought to be, for the decision of the High Court to be overturned, they need to overturn each single resolution. If even one stands in terms of majority, then there'll be a problem. So if we have a majoritarian decision overturning the entire resolution in the High Court, which are 22, then we have BBI movement coming back. Now, if then even one resolution becomes a constant holding of all the judges, then it means that the BBI movement is defeated. And therefore, we need a majoritarian decision as to overturn all the 22 resolution. And it's not, they have seen from Sichale's approach, maybe it is not completely impossible.
To overturn?
Maybe it's not completely impossible. Let's see what happens.
One of the proponents says if it's defeated, he's not going to go to the court to the Supreme Court.
That is, you see, there are many parties there are many parties. So it's not up
any
to,
party can go.
As himself, he may not go. But I can assure you, there are 99% chances it will end up in the Supreme Court. And I would loved it to go to the Supreme Court myself to test again the elasticity of our Constitution and its application.
Okay.
Let's have the highest court pronounce itself on this so that then it binds and cascades down to everyone.
Okay. We have talked about the legal consequences of whichever way this goes, and we've also noted how important it will be to jurisprudence. But what is the political consequence of this? What is the political? If it's upheld, they uphold the Constitutional Court, or they disagree with the Constitutional Court. What is the political implication?
Loosely put, BBI and therefore the reforms that are proposed were an endorsement of coalition government. Basically, that's what it was doing in terms of expanding the executive, so that then eventually we have the executive occupied by as more people as possible, and of course to cure certain mischiefs that have been there, meaning the cycle of violence and so on and so forth, and there'll be explanations to that. Now, shall we therefore have coalitions? We shall have the coalitions only in the context of the Political Parties Act, not within the constitutional framework. Meaning, therefore, people come to cooperate, but within a scope of very few positions, and therefore making it more difficult to form coalition, because it means we have a president and a deputy president. We do not have an expanded environment where everyone then sits within that context. The only place of application will therefore be the cabinet, where there are many positions to share, as opposed to the main executive position, as would have been if if the executive was expanded as proposed in BBI. So political implication is that the negotiations may be affected, as we've seen in One Kenya and so on and so forth.
But it said that if it passes, if BBI passes, it's good for all parties.
Well,
because in terms of they expanded, for example, executive.
For purposes of the negotiations that are going, and it's mirrors. The negotiations are going on mirrors on BBI.
Yes.
So if that happens, if BBI then
they're
passes,
working with that in mind.
Yes, that in mind. Okay. If it doesn't, then the statute has to change.
Okay.
For instance, everybody wants to occupy presidency or near as possible or proximate to presidency, meaning in the executive, because that's a seat of power, ultimate seat of power. If that doesn't happen, then you realize that negotiations must change. Scope of interaction among the most influential politicians in the country will probably have to be re-engineered.
Okay. Losers and winners, are there losers and winners in this? Just in one word.
I think losers will be the proponents.
Okay.
And winners,
so they are losers?
Yes, there could be losers. Yeah. There will be losers to the extent that those that are proposing, the proponents would lose of BBI. And if it was the other way, then the proponents of BBI will win. But I want to look at it this way. It's not per se winning or losing in the context of strictly the well-being of Kenyans. I think it is important that we are testing our constitution and its elasticity and application, how it serves us.
That only makes the lawyers happy.
Yes.
That's what makes the lawyers happy. Yes, not the politician.
Yes.
Stay with me. We're coming back. But now that we're talking about political implications, just what are the likely political shockwaves of the revival of the buried or the burial of the recent nullified Building Bridges Initiative reforms? Well, this is the question that a lot of you have been asking and is in your head. And of course, political guns, their strategists, analysts, pundits, they're all asking as the Court of Appeal sits today to decide the fate of the BBI bill in an appeal that involves, among other parties, President Uhuru Kenyatta and of course Raila Odinga, plus a host of other parties. On our continuing special, our senior political affairs reporter, Murimi Mwangi, paints the picture of likely options for top political leaders as today's ruling gets underway.
Consistent, unapologetic, and relentless in their quest to amend the 2010 Constitution through the now famous Building Bridges Initiative sealed in this March 9, 2018 handshake, President Uhuru Kenyatta and former Prime Minister Raila Odinga seemingly have had their fate conjoined at their political hip bones.
The moment calls us to create a constitutional order that will long endure and survive and not be a conflict-stopping constitution.
Yet with the duo still struggling on how to resume play of the BBI reggae tune, after the High Court unceremoniously pressed the stop button with their May 13th verdict. Kenyatta and Odinga easily top the list of political guns most anxious about the coming Friday appellate court verdict on the BBI. For Kenyatta, analysts argue the BBI was to be a pillar of legacy for national unity, a foundation upon which Kenyatta was to also manage his Mount Kenya backyard's political future after his exit, with fresh provisions for demarcation of electoral boundaries, including constituencies with more emphasis on population quota. The BBI equally a critical political yardstick, through which Kenyatta was to manage his succession, introducing amongst other goodies an expansion of the national executive to accommodate an additional post of Prime Minister and 2 deputies. A prominent proposal in the constitutional amendment push, which has been the greatest reference point of Odinga's allies in the former Prime Minister's quest for new political alliances, and a key component of their promise to millions of opposition supporters to finally find a place in government after next year's polls.
If the scenario is that where the Court of Appeal appreciates the decision of the High Court and upholds the decision of the High Court, then means that it's only the Kalenjins that will negotiate with the Luos, or the Luos negotiate with the Kambas, or Kambas negotiate with the Mijikendas. And then we shall have narrowed the gap, or narrowed the scope and the space for negotiation.
We were having a conversation with the nation. It is not something that ODM is invested in. It's just a conversation, Murimi. In fact, I have said, and I can repeat here, ODM will move on so fast from this BBI conversation, you people will be shocked. Because for us, really, it is just a conversation.
Yet also caught in this anxiety are the One Kenya Alliance proponents. ANC leader Musalia Mudavadi, Wiper's Kalonzo Musyoka, Ford Kenya's Moses Wetangula, and KANU National Chairman Gideon Moi, having been key allies to the Kenyatta-Odinga axis in the push for BBI, a power struggle that has been seemingly against one man on the other side, consistently publicly mocking the BBI, but eyeing what insiders say is likelihood of cashing in on the same should the court revive the constitutional amendment push. Deputy President William Samoei Arap Ruto.
The Deputy President has been clear that he will lead a no, he shall not lead a no campaign against if BBI is allowed. So from where I stand, if they allow, the owners of BBI can proceed, they can do whatever they are, but they must be aware that the elections of 2022 must happen.
What people should be asking is, why is he opposed to a document that seems to be spreading power? Why is he opposed to a document that seems to be advocating for inclusivity? Then the opposite can only be the truth, that he would rather exercise power absolutely and have proper control.
When you think about BBI, there are a couple of things that might not be favorable to anyone. And anyway, every constitutional amendment has never been 100% for everyone. But substantially, it talks to the people, even the people who have been opposing it. And then they're talking about empowering at the local level. There cannot be any better empowerment than taking more money to the grassroots.
It is a wait and see, because as you know, in Kenya, as much as we want to rely on the legalities, there are also other machinations in between. And especially when you have a regime that uses both covert and overt power to intimidate other officers.
The timelines to the conclusion of any subsequent appeal at the Apex Court will be critical to provide closure to the referendum debate, to pave way for the August 9th, 2022 general election, a game of political cards that will inevitably have a victor and political casualties as realignments intensify in the Kenyatta succession race. Moremi Mwangi, KTN News.
And of course, there's a lot of interests that are involved in this. At the end of the day, it's good for the country, especially for the lawyers like George Kithi. It makes them happy, stretching the Constitution, testing areas of the Constitution never tested before. In fact, I like this conversation around the basic structure, because everyone is talking about it.
Yes.
Before this, no one was talking about basic structure.
Yes.
It's very interesting. I'll go back to basic structure. There's something I want to ask you on the basic structure.
Yep.
But when we spoke about processes, one of the things that we forgot to talk about was public participation.
Yes.
It's important for two reasons. One, it's a requirement. And secondly, there's the will of the people who exercised it, the people who okayed, the people who signed, where it went through the constituent assemblies. So there's the whole of that picture that we are looking at. But at the end of the day, when it doesn't go through, where does that will reside? But let's talk about public participation broadly. Why is this important even to the court that there was and there's compliance with the Constitution?
Now, the introduction of public participation in the 2010 Constitution was so that people participate in the affairs of the public and express themselves so that not disenfranchised. Remember, 2010 Constitution was people-centered, was people-centric. Mm-hmm. Now, public participation in the context of BBI was first, of course, the process itself towards the establishment of the draft, the draft itself being released to the public. Now, there has been two arguments. One is that, remember the argument that there were as many copies as there were being distributed, yes, and that there was no uniform copy. There doesn't seem to have been evidence that was placed before the judges on that. But what seems to have caught the eye of the judges in their reasoning and analysis was that public participation would have taken a certain path as analyzed by the High Court. And there are some steps that seem to have been drafted as constituting what public participation ought to be. But the Court of Appeal judges seem to say, in one limb, one argument, one school of thought, that public participation was not adequate on account of the fact that there ought to have been as many copies and in languages as would have been understood.
Yes.
But the other scope is there have been notorious debate on BBI even to date. It was not an instant or an event. It took so many days. There have been promotions, there have been roadshows, and copies were availed. And therefore, in the context, who then bears the burden to prove that the public was properly participated and enabled in order to participate? It is the person who proposes to engage the public, and not the public itself. So it's not the public to go to come to the Court of Appeal and say, we were enabled.
We were involved.
It is the evidence. The evidence must come from whoever wants them to be involved, meaning IBC in this instance, or whoever the promoters and proponents are.
Okay.
So other judges are holding the school of thought that there was adequate public participation. Others are holding the school of thought there was no adequate public participation. Again, it's the weighting. Where do you put the weight on account of how people have carried themselves and have enabled themselves? And this continues. So we are waiting for the other judges. Let's see what school of thought they come from. But I'll explain this way. In the context of law, there are what we call liberalists. A liberal person is one who allows scope and the largesse of argument, so that then you admit as many arguments as possible and opinion. Your opinion is not as radical as it should. But then there's the school of thought where a person is called a positivist. Now that person it's either black or white. There are no gray areas. So there's no compromise as to the intensity of argument. You become more aggressive in application of law, while you are less aggressive in application of law. Some of these judges, for instance, I have seen Sichale taking a position of a positivist. I have seen others are liberal in admitting arguments that otherwise would be on the fence. And we then will have a group of liberalists winning in terms of the scope of judges and their decision, meaning that becomes the majoritarian, or we have the two positivists also putting a school that wins. So it's more about numbers now. It's down to numbers. Like I said, it looks like penalties, and we see who scores more. the people that score more will either be for the proponents or for the protagonists on the opposite.
Okay.
Yes.
Majorly, some of the people, I'm still on that point, some of
Yes.
the people who went to court, basically this was public interest litigation.
Yes.
But is that a point of consideration for the judges, that the public might be interested really in amending the Constitution?
Yes. That's a question which was asked actually in the decisions, whether this is what Wanjiku wants.
Yes.
And they traced this to the history of the current constitution and also the previous constitution, and in fact the history of constitutionalism in effect. And they have analyzed what Wanjiku would have wanted to see in how they brought about this constitution and the engagement in reforming the constitution. And one of the schools of thought is that it has to be elaborate and Wanjiku-centered. That's what we are talking about.
Okay.
So I think, as matters stand, is that how Wanjiku ought to be engaged is a percentage or a content that ought to be placed on the scale of justice. Something, yes, Wanjiku participated adequately, and something that Wanjiku did not participate adequately. Like I said, a judgment remains an opinion of a person who is a judge.
Yes.
And that, therefore, the judges are expressing their opinions, and eventually what will be binding is the component of what will be sum total of the most of the opinions on one side.
Okay.
Yes.
But even when that happens, I'm just looking at the whole process of doing the amendment, and I'm still thinking about the people who truly believed. You know, this can only go two ways.
Yes.
So I'm still thinking of the people who truly believe that indeed they need to amend the Constitution, assuming that they agree with the Court of Appeal. I mean, the High Court.
Now, I think there are many good things in BBI. Let's just face it. The content of BBI, there are many things that are there that probably ought to see the light of the day. However, I think we are having this situation because BBI was timed to the next general election. That's where the controversy probably and all this hype comes from. If we had 3 years ahead or 2 years ahead, we wouldn't be worried in the manner that this thing has taken, the angle the whole decision has taken.
Yes.
Because you realize that if we have the 70 new constituencies and they are to be used in the next general election, and we have the new positions as will have been created in the executive to be used in the new general election, like we've discussed before, it contextualizes and rearranges the political environment of the country. Even this, if the BBI is refused, for instance, it then contextualizes and rearranges the political environment. That's why then the next general election is looked at with the preceding events of what happens to BBI.
Yes.
And therefore BBI has a context and is aligned to what happens in the next general election. It is a fact. It makes or break certain political events as we move towards the next general election. So either we use it in the next general election or we don't. Now there may be further ramifications and consequences. For instance, do we keep the next date of election or do we remove it so that then we are rearranging our affairs as a country in the context of BBI?
Okay.
Yes.
When the chips are down, there are two things that can happen, and you'll correct me if I'm wrong. It's either the judges agree entirely with not entirely, but agree whichever way with the High Court, or they disagree. But most important for me is if whatever way the judges, I'm just being careful because I don't want to look like we already know how this is going to go. So at the end of the day, when the chips are down, to Kenyans who have been watching this, will we have directions? You see, I'm becoming careful. Will we have direction from the judges? Or we'll have, how do I put it? Will they, my question is there direction that we are likely to get? They're likely to say, this is wrong, this is wrong, this is wrong, but this is the way you should go with it.
Now let me pick it up from there.
Yes.
What we expect to achieve, number one, is was the High Court right or wrong in stopping BBI?
Yes.
But that is the sum total, adding every decision, the sum total of the decision. I think eventually, and going deeper than that, is that there are certain resolution of the High Court, of the 22, there are certain resolution of the High Court that are going to fall by the wayside. I say so because I do know, for instance, now, and I agree even myself, where I stand as a lawyer, even without hearing the other judges, that the resolution against the president was wrong. You have not heard him, and you cannot there condemn someone unheard. Nobody would want to be condemned unheard. It is a principle, cardinal principle of law, and we can't fight with that. The president was not heard. He was condemned unheard, and therefore we can't continue to sustain the decision of the High Court. However, the other resolutions as to public participation, as to the basic structure, and so on and so forth, as we have traveled through, I think some will fall by the wayside. However, even if one stands, BBI stops. So it means there must be a majority that overturns.
Even if one
stands of the decisions of the High Court,
that's where
against BBI,
yes,
BBI stops.
Really?
Yes. So out of the 22, we must overturn each single resolution of the High Court of the 22. It is a tall order. Is it possible? From what I've seen, yes, it is possible.
Okay.
Yes.
Okay.
Yes.
Regardless, and it's going to be on majority basis.
Yes, majority basis. So the majoritarian here are going to win.
That is because if you look at ways of amending the constitution, perhaps they can throw away the referendum, but they need to allow leverage, and that's where the directions come.
No. You see, directions are when they are sought. The Court of Appeal is not a court that wants to put directions. The Court of Appeal decides whether the High Court was right or wrong, purely, and
that's why I ask best interest, because they are looking at people also. That's why I was interested. Do they also consider the best interest of Kenyans?
Unfortunately, that window does not repose itself in the circumstances. The best interest of Kenyans is whether the High Court properly directed itself or did not direct itself properly, period. That is the context in which we look at the context before the Court of Appeal. So it must only restrict itself to what was said in the Court of Appeal, in the High Court, the evidence there, and review. It's more of a review of what the High Court did.
And if it was to go to the Supreme Court?
Yes. The Supreme Court will then look at the Court of Appeal decision and also look at the High Court decision, meaning the High Court decision, the Court of Appeal decision form a complete record of what will be reviewed by the Supreme Court.
Okay.
Yes.
We have a few minutes because they really keep time. So we have like a minute, if at all they keep time, because they said they'll be back at 2:40.
Yes.
What was the argument about omnibus?
Oh, yes. You see, we have about 70 questions that would want people to agree on, yet the answer to that, the decision to that will be yes or a no. So the argument was, how about if I agree to 52 and not the rest?
Yes.
So an omnibus seems to disenfranchise the voter to choose, because you can have majority of the content agreeing with, but only two you don't agree. Yet that opinion cannot be disenfranchised. You must be heard on that opinion. So I must be able to say no to what I want and yes to what I want. That's why then they're saying the argument there, and I think what they're trying to bring out as judges will be to discourage as much as possible a global mobilization of decisions, yet people are not heard on each single opinion of what ought to be a reformist agenda.
Okay.
Yes.
To what end?
Well, so that ultimately every question must have a yes or a no. That is simply...
To what end? Why is it necessary that we have a yes or no?
Because then the vote must be an expression of a person's opinion, not a collective opinion. So that when I like 45 out of the 70, I can express my opinion for a yes out of 45 and a no for the rest. If I want 69, I can say yes to 69 and no to 1. And then we know what has passed and what has not passed. That's a tall order again. So it means the entire substratum. In terms of direction, I see that to be part of the direction that they're giving, that probably you may need to reconsider what you need to reform and whether you can wait for the others or go through parliament.
Okay. It's 1440. I guess they're going to go back.
Yes.
But I want to ask you the last and the most controversial question.
Yes.
How is it going to go? You don't have to answer if you don't have to. How do you think it's going to go?
I think it's a tall order to overturn the entire 22.
Okay.
But it's not completely impossible. But it's a tall order to overturn each of the 22.
Okay.
So BBI, if it will be historical, if BBI is allowed, it will be very historical. in the entire world to overturn 22 resolution of the High Court. The High Court cannot have been wrong in 22 instances.
Impossible.
But it can be wrong. I mean, there's a mathematical chance there.
Okay.
So let's wait and see. But it is a tall order.
It's a tall order.
Yes.
So meaning?
Meaning it's highly likely
that they will sustain the constitutional.
They may sustain,
yeah.
But I think it's possible.
It's possible to.
Yeah, but again, politically speaking, there seems to have been a conviction that they can understand the language. The players are saying we can move on even without BBI.
Okay.
So there has been probably a preparation over this over time, yes.
Do you think if it would go the other way, the opponents will go to the Supreme Court?
Either way, it will go to the Supreme Court.
Either way.
I can tell you, it is the lawyers to decide.